in this country. Thank you, Mr. Speaker.
Honourable David Parker.
Mr. Speaker, ever since we had the United States some years ago embarking upon Operation Enduring Freedom, or the Coalition of the Willing, I've been suspicious of loaded names when they come before Parliament. So I was somewhat intrigued to hear all of the speeches so far in this debate to be talking about hardcore cartel behaviour. And immediately I had something springing to mind that was in the publishing industry that wasn't really at the Mills and Boon end of romance. But then I looked further at this bill and I saw, other than in the explanatory statement where there is this loaded reference to hardcore cartel behaviour, beg your pardon? Domicility. No, I'm not talking about domicility or other hardcore cartel behaviour in the vernacular. So I was surprised to when I read the bill, having picked up the copy that was on the table in the House in front of me, to, other than in the general policy statement, find no reference to hardcore cartel behaviour, because it actually isn't a term of art or a term of science, or indeed a reference to hardcore publications. Mr. Speaker, I think it's intended to be a reference to bad or serious cartel behaviour rather than some sort of cartel behaviour that might not be quite so serious. So, Mr. Speaker, after that little diversion, I think it is appropriate to record that there are incidences, there are repeated incidents around the world, including in New Zealand, of inappropriate cartel behaviour by certain large industries that have dominance. A small number of players who can influence price inappropriately to their commercial advantage, to the disadvantage of consumers who have to pay more for their products or can't get them when they should be able to. And we've seen instances of that, some of which have been referred to by the Minister already and by my colleague, the Honourable Clayton Cosgrove, who made reference to some of the wood chemical price fixing that was going on, which cost New Zealand industry a considerable amount. Perhaps the largest of these events to have happened in New Zealand recently, which is referred to in the regulatory impact statement, which is on the table of the House, dealt with air freight, which was at a cost of some $200 million over a period of 7 years, which shows that the additional money that can effectively be stripped out of the New Zealand economy, out of the pockets of consumers, to the benefit of corporates who are embarking upon illegal anti-competitive practices, can be quite significant. So this legislation attempts to control that. If we want another example of where the ethics in business are sometimes less than they ought to be, of recent note has been the controversy in respect of the bank rates, the LIBOR rates in the United Kingdom and in the United States, where there was effectively cartel-like behaviour over there, which led to interest rates being set to the benefit of banks to the tune of probably billions of dollars over the period, and that would effectively have been at the cost of other participants in the economy. Mr. Speaker, cartel behaviour can exhibit itself in a number of ways. You can have an agreement to charge prices that are less than competitive. You can have agreements to carve up market share in a way that results in less competition, that results in higher prices. You can have agreements to limit the supply of a good or service in an artificial way, which, because there is an inadequate supply of that good or service, the price is driven up, because there are more people that want to acquire that good or service than there is available to be purchased, because of this constraint on supply that is artificially orchestrated by those within the cartel. So all of those things have to be covered. As prior speakers have said, you also have to be careful that you're not stopping things that are not inappropriate levels of collaboration, or in some cases vertical integration of some aspects of industry, can be in the interests of consumers and can be an outcome of competitive behaviour. which is to the advantage of society, because prices aren't higher than they need to be. And we all know that if prices are higher in one area, then something else suffers in another. For example, if someone has to pay too much for their electricity, then they might not be able to buy some clothes that they need for their kids, etc. So whilst this bill is good insofar as it goes, it's interesting to me that the government is lauding the fact that they are introducing competition in this area, where in another area of the economy they're probably causing a cost to the average residential consumer of about $200 per annum as a consequence of what will be the effect of the state-owned enterprise sale. We know that the average amount that's currently charged by a state-owned enterprise to a residential consumer is about $200 per annum less than the private sector competitors. We know that the electricity market is limited in its competition. That's why it's got so many rules. The rules for the conduct of the electricity market are thicker than the Bible, and in an effort to make that market more competitive than it would otherwise be. It's still not a perfectly competitive market, and we know from the analysis that's been done by Molly Mellish and others, and it remains uncontroverted despite the fact that some of the National Party, or I've heard Tony Ryle taking issue with a very small part of her analysis, trying to discredit the whole thing, when we know that in reality the absence of true competition in that market, followed by strengthening this private sector effort to try and maximise profits through increasing prices in the electricity sector, will have far more effect on consumers than this Commerce, Cartels and Other Matters Amendment Bill, which will whilst a worthy thing for consideration by this Parliament, will not be as influential on the interests of New Zealanders as will the effect of the sale of interests in those state-owned enterprise companies, where the prices will move towards the private sector competitors following privatisation of those public company shares. So, Mr Speaker, whilst the Labour Party supports this bill, I note that it will not have as much effect as that other measure that I've talked about, which goes in the other direction. Mr Speaker, one of the reasons why it's necessary to update this is because we know that the pernicious effects of cartel behaviour can be wide-reaching, and we know that currently the penalties are inadequate. If you're a cartel and you get away with it for a period of years, the civil penalties at the moment are so low that you could be quids ahead, despite the fact that you eventually get caught and be brought to justice through the New Zealand courts. The civil penalties will be less than the amount that the cartel has taken out of the New Zealand economy. So, Mr Speaker, for that reason it's necessary to change the penalty provisions to make it clear that the payment that can be sought from the cartel more accurately reflects the loss that has been caused. The regulatory impact statement makes the point that even after this legislation is passed, not all cartel behaviour will be caught. It's very hard to pinpoint this cartel behaviour on occasions where some of the conduct is commenced outside of the shores of New Zealand, and these arrangements are very opaque. And they estimate that the regulatory impact statement, if I read it correctly, estimates that even after this bill is passed, only about a third of the cartel behaviours, on best estimates, is likely to be uncovered, which means that two-thirds of the cartel behaviour will go undiscovered and unpunished. So this will not be a universal panacea to the problem, but it is an appropriate step which will align us more closely with the steps that have been taken in other jurisdictions, other Western jurisdictions, who have identified this problem does need to be addressed and have introduced penalties similar to those that are being proposed here. Mr Speaker, the closest comparison is probably in Australia, and they've had this for a couple of years, which does point to the fact that this amendment in New Zealand is probably overdue rather than ahead of its time. Thank you, Mr Speaker.
Dr Russell Norman.
Thank you, Mr Speaker. I rise to speak on the Commerce, Cartels and Other Matters Amendment Bill on behalf of the Green Party. The Green